Yes, we are.
Okay, then we will go on the record. The time is 6:02 p.m. and this is the hearing for Deschutes County file number 24721-1067-PS, a request for a land use compatibility statement. My name is Tommy Brooks and I'm the hearings officer in this matter. We are holding this hearing in part through electronic means. So before we turn to the substance of the hearing, I'll turn it over to Ms. House to describe how that electronic process works. Ms. House?
Thank you, Hearings Officer Brooks. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. Tonight's hearing is for a land use compatibility review for an extension of community sewer services throughout the unincorporated community of Tumalo. So I'll begin the hearing by explaining the format for tonight's hearing and then how those that are interested in testifying can provide their testimony. Then Hearings Officer Brooks will provide his hearing instructions. Then I'll provide a brief staff report. The applicant will then present its testimony and evidence. Next, interested persons will be invited to testify and present their evidence. The applicant's then afforded a rebuttal opportunity, and then closing remarks can be made from staff as well. So tonight's hearing is a hybrid meeting format where both in-person and remote participation is allowed. I do want to note for those remote participants, if for some reason the connection is interrupted, please give us a few moments to get back online. This hasn't happened before, but if it does go down, it probably will take a few minutes. So if you can be patient, that would be appreciated. And I also want to note that if your own connection becomes interrupted, please be sure to log back in using the same link or phone number that you've called in on. For our Zoom participants, it's important to note that right now everyone is an attendee. This means that your audio and video are not turned on. We're not going to hear anything or see you on our video. But when you want to provide your testimony, you will have to be elevated to a panelist. And as a panelist, your audio and video will be recorded. And I'll go over how to use those functions in just a moment. So if you're attending in person tonight and you want to testify, please make sure you've added your name to the sign-in sheet. It's, I think, sitting over there still. You didn't grab it, right? And this list will be used to call up each person for their testimony. And if you're attending remotely and want to testify, I'll add your name to a sign-in sheet in just a moment. So as a Zoom participant that has joined using a computer, when you become a panelist to provide your testimony, there are a few features you want to be aware of. The first is your mute button. This will be found in the lower left-hand corner of your screen. If you click this, it will mute your microphone. You may want to do this if you need to talk with your legal counsel and you don't want your audio recorded. Next to this button is also a stop video feature. You can use this again to black out your video if you don't want to be recorded if you need to talk with your legal counsel. The other important feature I want to point out is the raise hand button. This will be used at a couple different points in our hearing tonight. This will be in the lower right central area of your screen. You'll need to click this in a moment for you to be added to the list to provide testimony tonight. And if you've called in, so dialed in, not using any type of smart device or a computer, you'll have similar features, but you'll need to use your keypad. If you need to mute your phone, you need to dial *6 on your keypad, and to raise your hand, please dial *9. You may want to write down, especially *9 if you have a question. This will be how I will be notified that you need to interact with us. So at this time, for any remote participants who wish to testify, please use the raise hand feature now. Computer attendees, again, you'll need to click the button. And anyone that's called in remotely, please dial *9 on your keypad. Keep your hand raised until I get your name. One by one, I'm going to ask our producer to elevate each person with their hand raised. I'm going to ask for your first and last name and whether or not you're providing testimony in support, opposition, or neutral to the applicant's request. This may take a while, so I appreciate everyone's patience as we go through this. We'll be as expedient as possible, though. Yeah. So Alice, I think you're now promoted to a panelist, but can you confirm your first and last name and if you're providing testimony in support or opposition? Oh, there she is. Alice, I think you'll need to unmute your microphone.
How's that?
Perfect.
Okay. Sorry about that.
So can you confirm your first and last name and whether you're providing testimony in support, opposition, or neutral to the applicant's request?
First name Alice, A-L-I-C-E. Last name Long, L-O-N-G, and I'm in opposition.
Great. Thank you. Can you elevate the next person? And Greg, I think you'll need to unmute yourself. There you go.
Yes, Greg Sweeland. Last name is spelled S-V-E-L-U-N-D, and I am neutral.
And Greg, are you with a state agency?
I am with Oregon Department of Environmental Quality, yes.
Great. Thank you. Mm-hmm. Hi, Ives. I don't know if that's how you pronounce your name, but you'll need to unmute yourself.
Did you get that?
I can hear you now. Can you repeat your first and last?
Okay. The name is Eve. First name, Terling. Last name, testimony and opposition.
Great. We could take the. All right, Paul Granberry, I think you're up next. If you can unmute yourself.
Yes, hi. Paul Granberry, last name Granberry, Paul, P-A-U-L, and testifying against.
Thank you. Jim Guild, you'll need to unmute yourself so we can confirm if you're providing testimony in support, neutral, or opposition.
Yes, testimony in opposition.
And your name?
Nunzi Gould.
All right, Carla, it looks like you're next.
It's Carla Langford and in opposition.
Carla, can you spell your last name for me?
Langford.
Thank you. Dawn, can you hear us?
Oh, yes. My name is Dawn Lillis, Lillis, and I'm in opposition.
Thank you. All right, Linda, can you unmute yourself?
Can you hear me right now?
I can.
Okay, this is her husband, Patrick McGowan, in Tumalo, in opposition.
And Patrick, can you spell your last name for me, please?
McGowan.
Thank you. And is Linda also testifying or just you?
She's in opposition also. She's right behind me.
And does she want to provide testimony as well?
Not at this time.
Okay, thank you.
You should spell my last name, F-E-R.
Gabriel, can you unmute yourself? You're the next panelist.
Yes, I'd like to, in opposition, please.
Thank you. Yes, go ahead. Yeah. So Linda, you were elevated back to a panelist. Did you want to testify as well, or did you accidentally raise your hand a second time? Patrick McGowan, do you mind unmuting and just confirming whether or not Linda Ferguson wants to provide any testimony?
Okay, I'm unmuted, and Linda is right next to me right now. She wants you to spell your name.
It's Ferguson, Ferguson.
Great, thank you.
Thank you.
Thank you.
All right, so my producer just confirmed that there are no more hands raised at this time. Oh, okay, sorry, one last minute hand raise. We're going to elevate Megan in just a moment. Megan, can you confirm if you're going to provide testimony in support, opposition, or neutral to the applicant's request?
Yes.
Which category?
In support.
And can you spell your last name?
P-E-N-A.
I'm sorry, could you say that one more time?
Sorry, P-E-N-A.
Thank you. Yeah, go ahead and elevate him, I guess, just. Mr. Kobach, you've now been elevated to a panelist. I believe you're representing the applicant, but can you confirm? We're not hearing any audio on our end if you're trying to. Mr. Kobach, do you mind unmuting? Oh, it looks like you are now.
I did.
Okay. And
Is that better?
Yep, I can hear you now. Thank you.
Yeah, I'm just confirming that I'll be speaking on behalf of the applicant in favor of the application.
Larry, can you unmute yourself and confirm if you're here to testify in support, opposition, or neutral to the applicant's request?
Yeah, I'm the president of Tumalo Property Owners Association, and so I'll be testifying in support of the application.
Okay, as the applicant, correct?
Yep, as the applicant, yes.
Thank you. And Jessica, can you unmute yourself as well?
Yes, I am Jessica Kernian.
And are you in support?
And I am in opposition.
And can you spell your last name for me?
Kernion.
Thank you. Okay, so we're not seeing any more hands that are raised. I don't know if anyone called in, but *9 is your raise hand function. I do have 3 people in person on the list. Dale Peer. And are you in support, opposition, or neutral?
I'm neither. I just want to clarify Laidlaw Water District's position in this as stated in some of the comments.
So neutral, probably?
Correct.
Okay. Paul Dewey? Opposition or? Okay. And Joel Gosser?
Forward.
Thank you. Okay. All right, so I think we have everyone on the list now. Thank you for everyone's patience. So the order of testimony for tonight will begin with the applicant, then anyone in support of the applicant's request. Remote participants will be asked to provide their testimony first, then in-person participants will be called up next. The next group is anyone in opposition to the applicant's request will be invited to testify. Again, remote participants will go first, followed by in-person participants. Then anyone that's neutral to the applicant's request will be asked to testify. Again, remote participants first, then in-person. And lastly, the applicant is afforded a rebuttal opportunity as well. Hearings Officer Brooks and myself are responsible for an orderly hearing tonight. Anyone that's being disruptive may be asked to leave. I do want to note, if you have written testimony tonight, you can submit that to me. If you're providing oral testimony, please hand me any written testimony before you start. And then if you are attending remotely, you'll need to email me anything that you want and entered into the record tonight. To do that, my email is my first and last name, so caroline.house@deschutes.org. Please note any submittals that are greater than 20 pages in length, include color figures, or need to be printed on a sheet size larger than 8.5 by 11. You'll need to submit a hard copy as well. So at this time, I'm going to ask if there are any objections to this hearing format. If you're a remote participant, you'll need to use the raise hand button or dial *9. All right, so no hands are raised. I'm going to turn it back over to Hearings Officer Brooks.
Hey, thank you, Ms. House. As was just described, we are following the normal hearing procedures that are laid out in the county's code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. Again, I ask for your patience as we get through each of the steps, as we kind of go back and forth in this hybrid format. And as people did announcing themselves, I would appreciate if you begin your comments by restating your name, but also adding your address for the record. The application is being processed through a quasi-judicial proceeding. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards that are applicable criteria that have been identified in the public notice that announced this hearing, there are standards that are also set forth in the staff report, both of which are posted on the county's website. It's important that you direct all of your testimony to standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion, but I urge you to also explain why the criterion must apply, and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals, Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. My job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in that role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections that I may have to other participants or anything that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearings and not the substance of the application. And I do not have any ex parte contacts to disclose. Ms. House went over the order of the proceeding. It sounds like we have about 15 people in addition to the applicant signed up. Does that sound right, Ms. House?
Yeah, I believe 15 or 16, I believe, yeah.
So we're right on the bubble of where setting time periods might be needed. I'm optimistic that we don't need to set time periods. If everyone would sort of voluntarily keep their comments to 3 to 5 minutes, then I think we can get through this. If it does start to drag on, I may set time periods. Things you can do that are helpful to me, because it doesn't matter how many times something's repeated in the record. If someone who's gone before you has said something you agree with, rather than restating it, you can let me know that you agree with them, and we can be pretty efficient about this. I do think I'm going to change one part of the order. I think it sounded like there are 2 people signed up that are neutral. Was there a third one or just the 2?
Just the 2.
Okay. My understanding that Mr. Sweeland is from DEQ. So after the applicant goes, I'm going to invite Mr. Sweeland as an agency representative to also go. I think it's appropriate in this case to, since he's from DEQ and this is a request for a Lux that would go to DEQ. I'm not sure what Mr. Sweeland's going to say in his comments, but maybe it'll help sort of frame other people's comments as well. So that's the one person I'm going to take out of order that the order that Ms. House described.
And hearings officer, sorry to interrupt, but Dale Peer is here with the Laidlaw Water District as well. So I don't know if that is considered a similar agency testimony for tonight, or if you want to keep him in the standard order.
Yeah, I apologize. I missed his name. You said it's Dale.
And he's in person, so you wouldn't have his name.
Oh.
Dale Peer.
Got it.
And he's with the Laidlaw Water District.
Oh, got it. Okay. Yes, I assume the Laidlaw Water District is a special district, probably organized under 264 or something like that. So if that's the case, I would allow him to go right after DEQ.
Is that accurate? Yeah. Not yet, but yes. Hearings Officer Brooks, we're on the same page.
Okay, great. So we'll do those. We'll do those 2 neutral commenters right after the applicant. So with that, does anyone wish to challenge either my ability to hear this matter or to challenge the county's jurisdiction over this matter?
And there are no hands raised or anyone in the room with comments.
Okay. So we will jump to the portion where the staff report is delivered.
So I have a brief staff report for tonight. I want to highlight the key issue for tonight's hearing is based on the applicable county zoning standards is the proposed sewer piping and the road right-of-ways throughout the community of Tumalo a use that's allowed outright, a use that's allowed subject to land use approval, or a use that's not allowed. The applicant has submitted a State of Oregon Department of Environmental Quality Land Use Compatibility Statement form to the Planning Division for review. This Lux form is used by DEQ to determine whether approval of a DEQ permit will be consistent with Deschutes County's comprehensive plan and land use regulations. On the submitted Lux form, the applicant proposes to install sewer piping and the road right-of-ways throughout the unincorporated community of Tumalo, as well as a few areas outside of Tumalo. And what you'll see on the screen here is exactly what was written on their form for their project. They state it is an extension of service lines and the right-of-way, or abbreviated ROW, and they've also attached a written narrative that's in the county's application materials. I did want to spend some time tonight talking about the location of the proposed piping. What you'll see here on the screen, on the left-hand side is a aerial map of the unincorporated community of Tumalo and the boundaries. So everything in green is inside the unincorporated community of Tumalo's boundary. And then to the right on the screen is what was mailed out with all of the notices for this project, is the applicant's schematic for their project, which they have termed the Laidlaw Sanitary Sewer Master Plan. So if you have a notice, or you've been in email contact with me, or you don't have a copy of this, let me know and I can send it to you. Their master plan is broken out into 3 subsections. The northern section, what you'll see on the screen and on your notices, is the unincorporated community boundary for Tumalo is bolded in this darker color, and then the dashed lines represent the proposed piping location. So for the northern third, piping is proposed to be installed in Hopper Road, Putnam Lane, Tumalo Road, Beaver Lane, and Klein Falls Road right-of-ways. The central third, or what I'm terming the central third, is set up the same exact way, where the dashed lines represent the proposed piping location. So the proposed right-of-ways where piping will be located, or is proposed, will be Bruce Avenue, Wood Avenue, Strickler Avenue, 2nd, 3rd, 4th, 5th, 7th, 8th, and 8th Streets, Riverview Avenue, Pine Lane, Fir Lane, Elm Lane, Juniper Lane, Cedar Lane, Birch Lane, as well as Alder Lane. And the southern third of their master plan shows additionally that Bailey Road, O.B. Riley Road, and Research Road will also contain sewer piping. And I did want to highlight that their drawing shows 2 areas outside of the unincorporated community of Tumalo as also including new piping, or what I assume to be new piping based on the materials that have been provided to the county. The first, or the left-hand image that you'll see on the screen, this is just west of the Tumalo boundary, west of US Highway 20. And I believe this would be a connection or piping to their existing wastewater, the applicant's wastewater treatment facility. The other location that's outside of the Tumalo boundary is on the southern extent, and piping is shown as continuing in O.B. Riley Road outside of the unincorporated community boundary. So on the DQ Lux form, the county is asked to review whether or not the proposed use is allowed outright, allowed subject to land use approval, or a use that's not allowed under the county's zoning regulations. And again, this is the key area of the review and what staff is asking the hearings officer to focus his review on tonight. And I did lastly want to note that separate from this application, the County Road Department is initiating a Tumalo sewer feasibility study. And I know a lot of the comments probably would be very relevant to this project as well. So I want to make sure everyone has the right contact to coordinate for upcoming meetings related to that. So if you want to participate in that, please contact the Road Department. Their email is road@deschutes.org, or you can call them. Their number is 541-388-6581. And that concludes everything I have in my staff report, and I'm available for any questions from Hearings Officer Brooks.
Thank you, Ms. House. I don't have questions for you at the moment. I may at the end of the proceeding, so we can just go right to the applicant's presentation.
Yes, please.
Can you hear me?
hear you.
I can't get the video to work, so you're probably lucky you don't get to, or don't have to look at me. I'm Chris Koback. We've met before, Hearings Officer Brooks. Oh, there we go. Maybe this will work. Nope. Anyway, oh, there we go.
Can see you.
I'll proceed. That's bad. I represent the applicant. My address is 1331 1331 Northwest Lovejoy in Portland 97209. And I'm going to start by giving a little background. I won't keep it to 5 minutes as the applicant, but I'll try to keep it as tight as possible. A few years ago, Mr. Kine, there's a town plat for Tumalo that has it was the Laidlaw at the time, very old, and it showed a lot of small lots. And several years ago, Mr. Kine bought the Tumalo Feed Company and a bunch of the property that was on that old plat off of Highway 20. And the county agreed that those lots could be confirmed as buildable lots. They were legal lots. Well, they weren't big enough for septic systems, and what we understand to be true is that DEQ is not approving septic systems in this area due to some soil conditions and other environmental issues. So to get those lots developable, Mr. Kine had to figure out a way to get sewer. And so he applied for and obtained approval for a sewer treatment facility in EFU land above the property up on a hill. And then the system, how the system for those lots works is there's pressure lines that run mostly in the right of way there to right in front of the lots. Now there's no tanks or pumps or anything that's associated with this facility. This is the community facility we created. The individual lots have tanks very similar to a septic system. The only difference is that they go into a tank and there's some pre-treatment, and then there's a specific kind of grinder pump that works on the owner's property that then pushes the effluent through like a 3/4 inch line, that would be the lateral, to these pressure lines in the right of way, and then it goes up to where the treatment is up on the hill, there we go. So it goes up onto the hill, and that's where it's treated further and then sprayed onto the EFU land under the approved system. Now, when that system was done, there was initial land use approval for the facilities up on the hill. But for the lines in the right-of-way, Mr. Kine submitted a LUX. County approved it. There was no hearing. It was a similar DEQ LUX. Mr. Kine expanded the system once to serve a commercial property called Tumalo Junction or something like that. Again, there was no land use approval required. And so now we jump ahead, and there is a great demand for sewer system in Tumalo because of the DEQ issues with getting approval for new septic systems or even replacement septic systems. So given that demand, there's capacity up at the hill for effluent, there's capacity for treatment, and the proposal is to extend these pressure lines mostly in the right-of-way. I guess staff has pointed out there's a couple private streets involved, but for the most part it's in public right-of-way. And so the proposal is to extend these lines, and they're only like 2 to 4 inches. They're not big lines. They're 2 to 4 inch lines that will go in the right-of-way, and then these 3/4 inch pipes come out of the homeowner's property or the business owner's property where the tank is. And these lines are pressurized, and they will, as the pumps in the private owner's systems kick on, it creates the pressure and it forces the effluent back up to the treatment facility. Now, I've been doing land use for about 30 years. Your experience may be different, but I've never seen a LUX elevated to hearings officer. So this is kind of a new thing for me anyway. the purpose of a LUX is to determine whether it's compatible. And so when we submitted the LUX, we received information from the county that they wanted a detailed explanation. And what Ms. House showed you as that one handwritten statement on the LUX form is not the complete LUX. At the county's request, we submitted a very detailed explanation, which you should have, which kind of explained the history of the system, what we were trying to accomplish, and how we believed it was compatible with the zoning. Part of this was driven by a prior LUX that the county issued for adding one lot to the system. In that case, the county took the position that that one service line, they called it a service line. They equated it to EFU property, what was allowed in EFU property, and they allowed that with no review. So that brings us to what we're trying to do today, and really we see a couple of issues. The first one is a procedural issue, and that is the county has raised a question whether Mr. Kine and the association has the authority to submit an application for work in the right-of-way and perhaps on these private streets when he doesn't own it. We think that's really that misses the point, because a LUX is not a land use application in our view. We didn't submit an application, a land use application. What happened is we submitted a LUX and the county unilaterally treated this as an application. Again, in my experience, a LUX has not been treated as a land use application. It is a very straightforward form. It is a land use compatibility statement. And the only question is this use compatible with the regulations? Once that question is answered, if it is compatible, then there may be subsequent land use applications that have to be provided and submitted. But this is not a land use application. So we're kind of responding to this information we're getting from the county about this land use application when we never even filed a land use application. And so when it comes to authority, we think that issue really is not pertinent for today. Today is to decide whether the land use, I guess, since the county elevated to the hearings officer, the question is this proposed use compatible with the land use regulations in the county? We don't need to decide whether or not there's authority for a land use application because we didn't submit one. And if we have to, we'll have to deal with that issue at the time. And so that gets to the real core substantive issue, and that is are these 4-inch pressure lines in the right-of-way outright permitted conditionally, or not permitted? The county seems to agree that its definition of a utility facility is limited to a major structure. Like an example is a sewage lagoon. And the definition expressly excludes local sewer distribution lines. And so, with that in mind, our position is clearly what we're proposing is a local distribution line. Now, as an example of something that would be a main trunk or perhaps a major facility, I can cite 2 examples. One, I understand the city of Bend has an interceptor sewer line that goes out to a treatment facility somewhere in the county. And that line is, I think, 36 inches in diameter. And it takes effluent from many mains and et cetera and pumps them out, pushes them out of the city out to this treatment facility. Now that may be a major facility. It's 36 inches, it collects sewage from all over and it takes it out to a big treatment facility. That's dramatically different than a 4-inch local distribution line that we're proposing. Another one is the East Side Redmond interceptor. I think that's in the 30-some inch diameter. And again, multiple mains go into it and it goes to a big treatment facility. When you look at what we're proposing, there's only one component. It's a line. It's a 2 to 4 inch line. There's no pumps in our system. There's no tanks in our system. All of that's on private property, and we presume that's permitted outright under a building permit because it's comparable to a septic system. And as we understand the county's permitting for septic systems, all you do is get a building permit. There's no separate land use review for that. So our position is that this is absolutely a outright permitted use in all zones. And if you look at the county's alternative position, which is this would be a major facility that has to get land use approval, there are zones in Tumalo that do not allow utility facilities at all. So it would be a little bit ironic that you could have some zones where properties would get sewer and some zones where properties would be disqualified from having sewer based on the current county code. And the other thing that seems a little ironic is if this is a major utility facility and it wouldn't be permitted in certain zones in Tumalo, why would the county be sending out this RFP for feasibility studies for a competing system? It would be a waste of taxpayers' money to do a feasibility study for a system that, under the current code, couldn't serve properties in more than one zone in the city. And other zones, they would have to go through conditional use permit to get that done. So our position is, again, that based on the county's definition, the size of the lines, the limited amount of facilities we're putting in the right-of-way, we're proposing to put in the right-of-way, this has to be deemed a minor facility that is outright permitted and therefore compatible with the land use regulations. And then, like I said, after that determination is made, if there's land use review or permitting that's required, it comes later. For example, if it's an outright permitted use, one of the permits we may need to get for the right-of-way would be a public road permit, because we'd have to repair a small section of the road where the pipe goes in. Well, that would be a permit that would come later, and there would be other approvals through DEQ, we presume. They would obviously be involved, I think, in further approval, but we're going to hear from the DEQ gentleman. If there are private roads and this is an outright permitted minor use facility, there may not be any permits because it's private property and it's an outright permitted use. Maybe there's a grading permit the county would require, but we think it'd probably be outright permitted with no required permit. So that's our position for this, is that really we're not here on a land use application. We're here to determine one critical issue. Is this a minor facility or a major utility facility? We think the facts support one conclusion. It's a minor facility. It has to be outright permitted. That solves a lot of problems. We don't have zones that don't have the right to have sewer, some that do. It makes sense with the county's RFP. If they truly are going to put in a new system, they're going to have to deal with the same issues. So unless there are questions, we'll come back and rebuttal and respond to anything that we need to respond to.
Hey, thank you, Mr. Quebec. I think I do have several questions for you, just to try to get my head around the request. And one thing I can tell you I agree with is it is not often that a Lux will get elevated, to a hearing. I don't think it's never happened, because I'm familiar with a couple that have, but it is not normal. So I want to ask you a few things about the procedural posture first, and then we'll get to the substance. Because my understanding is the county's code has a couple different kinds of actions. There's a development action and there's a land use action. And it feels like the development action definition is sort of broad and encompasses maybe something like a Lux, but then gives the county the ability to elevate or to process, I guess, that development action as a land use action. So I feel like that's where we are procedurally. But I guess I wanted to float that to you to see if you have a response in terms of, are there procedural errors here that you think are happening? Is the applicant still okay with the county processing what amounts to a development action using a land use action proceeding, or do you think that as a hearings officer, I need to actually be looking at whether or not I even have the jurisdiction to look at this?
Well, we're not necessarily opposed to the process the county initiated. I guess the issue I was raising is that when the county decides unilaterally to make something, to elevate something to a development action, and then says, well, we don't know if the applicant actually has the authority to apply for this, that's where we were concerned, because we didn't file a land use application.
Right.
And so I think to hold that standard against us is really unfair. So as far as what the county did, if the county wanted this reviewed at a public hearing, and it seems to me that that was the primary motivation for doing this, is just to make sure that the community got notice of this, then I think they're entitled to elevate it as a development action. But I don't think they're entitled to use the fact that that they made it an application against us to say that we may not have the authority to process it.
Okay. Thank you. Thank you for that response. I think that's a distinction that helps me understand kind of where we are. The other, I guess the ripple effect of that is like the staff report still mentions a review period. And sort of the 150-day clock being at play here. In your comments, I think what you were saying was that you're not asking for permits. It's either already approved or maybe in a worst case scenario, additional approvals have to be obtained. But does the applicant have a position on, I guess, the rest of this procedure and if the 150-day clock applies?
Well, yeah, our position is if the county is going to elevate this to a land use level, then the county is subjecting itself to the 150-day period and all other procedural requirements for public hearings and everything else. Again, we're not challenging the county's ability to elevate this.
Okay.
All we're saying is if they're doing it, they can't say that we have a procedural problem in that we don't have authority to process it. We have the authority to file a LUX, and if the county wants to raise it to a higher level and invoke the land use procedures, it can do that. But it can't ding us and say we don't have authority to proceed.
Okay. Thank you for that. So I want to move to the substance a little bit more. I appreciate that you, in your opening, you veered towards that this is an outright permitted use. So that starts to get to one of the questions I had just coming into this hearing. I think Ms. House did a good job just sort of saying, the question is it allowed outright or some other approval needed, or is it not allowed at all? The LUX form is actually a little bit more nuanced than that. And there's probably 5 or 6, different options that the county could choose on that option. And only one of them is just sort of, yes, the activity or use is allowed. I'm sorry, I misread that. Yes, the activity or use is allowed outright by, and then parentheses, provide the reference for local ordinance. So I guess I want to confirm, I think you said in your opening comments, but is your sole basis that you think the county ought to issue the LUX based on that box in the LUX form, that it's the use is allowed outright? That is the sole basis?
We believe it is, and I think the county staffs in their report seems to acknowledge that if it's a minor utility facility, it is outright permitted.
Okay.
And so that's what we believe it has to be categorized now. And where we're coming from on that is we're unaware of any other utility company, gas company, water line, public or private, that has had to go through any kind of land use review for work in the right of way. When, for example, when a private developer has to extend sewer into Deschutes County as a condition of approval, they don't go through a supplemental land use review. They get a road permit to construct in the right of way. And so we asked the county in a public records request, give us all examples of when another entity or party had to go through land use review to do what we're doing, working in the right of way for the utilities. And the county's response, we have no examples. So based on the similarities of what we're doing to what everybody else has done in the county and the county's response to the public records request, we believe this has to be deemed to be on the same level as those other actions and be outright permitted utility work in the right of way.
And for that example specifically, are you comparing it to other sewer projects, or are you comparing it to all utilities, electric, gas, water?
Well, we're not aware of, we didn't get any examples from the county of any utilities work in the right of way that required land use review. And so what we're experiencing, we've observed private development where sewer has to be rerouted, and I think there's an area out on Highway 20 where actually the county is rerouting some sewer and water lines. And if there was a land use review required, that would have, our response would have elicited that information. And so when the county confirmed that there are no prior examples, we have to assume that those projects are also proceeding without land use review. And so we've noted many examples in the community where similar utility work is done either through private parties as part of land use review or for public entities where there's no land use review. And we have to assume that those are outright permitted utility, that's outright permitted utility work in the right of way.
So sort of the next layer of this then, the one thing I want to square with what you said compared to the materials that I read is sort of describing these lines as a local distribution line. And a lot of what was attached to the Lux talks about sort of transmission. And those are I don't know that, I haven't looked yet to see how the code defines those, but those are terms of art that are used in the definition of utility facility. So what I want to make sure is to understand your position is that whether or not something is a major or a minor facility is less to do about its function, but more about the size. I mean, I think you focused on 2 to 4 inches versus like a 36-inch, facility. And I'm trying to put your assertions in the context of the code language and have you help, point me to where I would go to find sort of the size that differentiates major versus minor, as opposed to a function that might differentiate major versus minor.
Well, the size came up because staff in its report said specifically, well, knowing the size of the line might help us determine whether this is major or minor. And so we thought it was clear, but perhaps it wasn't. So I'm clarifying that this is not a major line, so staff can check that box and say it's not a 36-inch line that we're proposing. It's a 2 to 4 inch line. As far as how it functions, we believe it functions as a local distribution line. When you call it distribution or transmission, it's purely local. It's in a relatively small area. It's taking effluent from specific properties and transmitting them a short distance to a treatment facility. It's not collecting from larger mains throughout the city. It's really a very narrowly circumscribed system that's designed to fill the needs for the Tumalo unincorporated community. And so we believe the size and actually the function, in fact, that it's just a line. Like I said, there are no other components to it, what we're proposing. Everything else that runs the system is either been approved upon EFU land or it's on the owner's property. And so we believe both the size and the function, when you consider that in context together, it's clearly a local distribution line. Unlike, the best example I gave you is that the Bend interceptor and the Redmond interceptor. Those obviously are bigger because they perform a different function. They collect sewer, a lot of it, from a broad area and transmit it to a large treatment facility. I think it's important to keep the scope of this thing in mind.
And my final question for you, I just wanted some clarification on one of your comments. I think you said under the utility definition, if it's a local distribution line, it's allowed in any zone. But you made some reference to the fact that there are zones in this area that don't allow any utilities at all. And I wasn't tracking exactly what you said about that. Repeat that.
Yeah, and on this staff, I think concurs with us. There are zones that do not allow utility facilities as defined in the code. If I read the definition correctly, and I think I do, local transmission, local sewer distribution lines are not considered utility facilities. So if it's a utility facility, then the zoning comes in, and there are zones where it's permitted conditionally, and it's not permitted at all. But if it's a minor facility, as I read the staff report, that's not even a utility facility under the county definition. And that's why the county takes the position that if it is a minor facility, it's not a utility facility, and therefore it's allowed outright. There is no approval required.
Okay, thank you. That's helpful in clarifying your original comments. Let me just check my notes. I think that's all I have for the applicant for now. So you'll, of course, get the opportunity to come back up for rebuttal.
Hearings Officer Brooks, this is Larry Kine, the applicant. Do I have a moment to speak as well, or would you?
Yes, I'm sorry. I understood Mr. Kovac to say that you guys were done. So if you want to go as part of the primary presentation, that's fine.
Yes, please, if I could. It won't be long by any means. You know, I think I wanted to go and mention a few things. You know, what Mr. Kovac is talking about is, you know, a 36-inch line is a vast difference where it's taking sewer from a whole section of town that is, you know, thousands upon thousands of people. But that line, 36-inch line, didn't need site plan approval. It still went inside the right-of-ways and across the highway department. So as he's talking about that, he's not saying that, oh, okay, that one would need it. He's just saying that one, you know, is one where you could see where maybe that could be elevated to it. But the county didn't do it. And so, you know, that's vastly different. When you talk about the scope of something, that scope is significantly larger than scope than we're talking about, and yet the county still didn't do it. You know, this is a very, very slippery slope for the county. If they did come in and they decide that a distribution line, be it a sewer line, a water line, a utility line, a power line, a cable line, anything like that is a major facility, development in the county is going to stop. Because you're going to have every single person out there that doesn't want any development to come in there and go file appeals. And for the county to go over there and put out an RFP for doing the exact same thing, I mean, I would hope they're not so inept that they didn't go look at their own compatibility in their own zone before they spent taxpayer money to put out an RFP. And they did that not only in Tumalo, but they also did it in Terrebonne, the same situation. This to me seems like the only purpose of this is for one thing, and that is to be able to go and get public notice to all the people. The rest of this whole thing seems kind of ridiculous. And I know there's a lot of people that are, you know, worried about, you know, this sewer line that is going to come in, that's the Tumalo Property Owners Association system, and that all of a sudden they're going to be assessed some, you know, large amount of money to hook up to sewer. Well, that's not the case. If they have an existing septic system that is functioning fine and they want to stay with it, they have no obligation to switch. In the event that they want to be able to take some of their property and further develop it and decide that they want to hook up to sewer so that they can take some of their property that was now a septic field and it was 3 or 4 or 5 lots and they want to hook up to this system, then they can subject themselves to a hookup fee and the association, the Tumalo Property Owners Association, and they can be subject to it. But no one's going to make anybody go hook up to this. The county is worried that they're reading their code that says that or the state mandate that is If there is sewer within 300 feet, then somebody has to hook up to that. I don't know that they're reading that properly. And that's only in the event that they have a septic system that fails. It doesn't mean that they have to hook up to it if they have a functioning grandfathered in septic system. That is for a governmental agency one. This is a private sewer system, and the state requires that all sewer systems have to either be owned and operated by a homeowners association. So the people that will be hooking up to this system will eventually own this system. It won't be Larry Kine. Larry Kine is trying to do a public service to the Tumalo area where I lived for many years that has not developed, that can further develop for the people that want to give them their individual rights. If somebody doesn't want to develop their property anymore and keep it the way it is, by all means, they can keep it exactly the way they want. But if they decide that they want to be able to utilize their property in a development way, which was the vision clear back in 1904 when the town plat was cited, they could hook up to sewer and they could go and they could further develop their property. That's all this is about. That's all I have.
Thank you, Mr. Kine. So since we're done with the applicant's presentation, as I noted at the beginning of this, I'd like to go to the two agencies that are present. So that'd be Mr. Sweeland first from DEQ.
Greg Sweeland with DEQ.
Mr. Brooks, can you hear me?
I can hear you. Thank you.
Great. So thanks for the opportunity to be here today. My name is Greg Sweeland, and I work for the Department of Environmental Quality. I'm in the Regional Solutions Program in the Bend office. The address is 475 Northeast Bellevue. And, you know, typically DEQ does not comment on local land use issues, though I am today because the agency has been asked by a number of people about whether this type of system potentially would be considered community sewer under Oregon rule. And I think the short answer is that if the project is approved and permitted and the boundary is pretty clearly defined at the local level, then it is likely that this type of treatment system would be considered a community sewer. And in Oregon, you know, the term community sewer refers to a system that has a defined boundary within a community. And so if a community sewer is proposed and that defined boundary is approved locally, then DEQ does have a role in reviewing that proposed system. And having community sewer legally and physically available also could carry potentially implications for owners of septic systems who reside within that boundary. And I'm trying to be careful about what I say because I realize that this is premature, and it's also not the issue directly of what the hearing is about today. And it's also speculative because there's other local approvals that would need to happen before the state is really able to fully determine what the rules are and how they apply to a given situation. But I did want to address that because it's been a question that has been posed to the community, to agencies, the county, and DEQ. And so I wanted to try and just clarify that one thing, even though I realize it's not at the heart of what's being discussed today with the local land use. And finally, anybody who is interested on this particular topic, I just wanted to remind folks that DEQ has already provided a written comment that really addresses what I've been mentioning. And that document is a record that's been submitted for this case. It was written by DEQ's Larry Brown, who unfortunately could not be here today because of a death in his family. But I just wanted to remind everyone that that is available. It's part of the written record for this case. And that's all I wanted to say. Thank you.
Thank you, Mr. Sweelan. I do not have any questions for you, but I appreciate you taking the time. And then I think that would take us to our representative from the Water District.
I'm Dale Pier with Laidlaw Water District. Our address is 64619 Unit C, Highway 20, Bend 97703. And I am here to strictly clear Laidlaw Water District association with this process. Is a lot of public comments have been made about what Laidlaw has done here. We have been said that we took it upon ourselves to form a homeowners association and call ourselves the Laidlaw or the Tumalo Property Owners Association, which is not true. Laidlaw Water provides strictly domestic drinking water to residents of within our district boundaries. We're formed under ORS 264 for small municipal utilities, and we have absolutely no participation with the proposed sewer, other than the fact that we did lease property on the butte to the Tumalo Property Owners Association to put their septic system and their drain field in. And for that, we received substantial compensation, and that is our only association with the Water District. It has been said that in the application that our property is addressed off of Bill Martin Road, and that is not our access to the property. That is in fact incorrect. Our physical address from the county is Bill Martin Road. We do have a driveway permit for Bill Martin Road, but we do have easements to our property, including our new well, through a private driveway off of Strickler Avenue. That is not our county address, so that is strictly an ingress and egress to our property on the hill. And I think that's the significance of what I got to say. Other than that, I have put all my comments in the public record that I sent to the county.
Right.
Thank you.
Thank you for your comments. All right, so it's going to take us to the rest of the comments. Ms. House, I was trying to keep track of if anyone had signed up in support, and I had noted that there was one maybe.
Megan Penna, who's a remote participant, and we have an in-person participant that's
Okay.
also here to support.
All right, we'll start with the remote participant.
Hi. So my husband and I have a business in Tumalo, and we'd be interested in connecting our commercial building to sewer, but we definitely don't want the residential area of Tumalo to be forced to hook up or to pay exorbitant fees to hook up. And I know that's a lot of our neighbors and friends' concern here. In ours as well, if that would be imposed on the residential portion of the map. But we definitely be in favor. We're in food service, and that's severely limited by the current regulations. And we just love to see downtown Tumalo blossom, and that's pretty limited right now with the current sewer and septic regulations.
All right. Thank you, Ms. Pena.
Thank you.
And for the person who's in person,
Yeah.
in support.
It will be Joel Gosler? Giesler, I'm sorry.
Good evening. I'm Joel Giesler, 1470 Northeast First Street, Suite 600, Bend, Oregon 97701. Let's see, I own 19889 8th Street, commonly known as Tumalo Mall. Well, it's known to me as Tumalo. It's a big red building. It's been there probably since the 80s. I bought it in around 1990, and I recently bought the Tumalo Food Court. This property consists of multiple 50 by 130 lots, which sit on approximately 5 acres. Currently, I cannot develop this property without sewer. And as the applicant suggested, the 50 by 30 lots or by 130 lots are too small, but won't support a septic system. There's 51 acres of commercially zoned property in Tumalo. Most of them are these small lots. Vacant lots are undevelopable. The old El Caparel restaurant and pizza parlor are an example. They're both gone. The new developments require costly sand filters or holding tanks which need to be pumped out on a regular basis, which is costly. Sand filters must be maintained, which are costly and eat up more land. If any person does not want sewer, don't require this, but it is not a reason not to allow sewer for others. What I've recognized on the staff report is that if approval or denial hinges on 2216, the planning director has discretion. The planning director has been presented by applicant many examples why a land use action is not required, including previous sewer systems with no land use requirement. Yet they push the decision off to you. Hearings officers should find that no land use is required as county has previously done, and then all other issues can be resolved. As far as right-of-way, county issues permits all the time to do work. And there's also a mention of private roads in the staff report, but I looked on Dial, and for instance, Birch Road is not owned by anybody. So I don't know who the applicant would contact because it doesn't list an owner. In conclusion, Tumalo needs sewer to develop existing lots and provide a solution for failing systems. I ask the hearings officer to approve application and allow this desperately needed utility to be established. Thank you very much.
Thank you, Mr. Giesler. Is that everyone that signed up in support?
Yes.
All right. So we will move to those who signed up in opposition. And I was just going to take them in the order that we did that they were introduced when you called for their name. So Alice Long would be first.
Alice Long. Hi, Alice. If you're still online and connected, can you please use the raise hand feature for us?
Can you hear me now?
I can hear you.
Oh, do you want my video on then? Or does it matter?
I will leave that up to you.
Okay, I'll leave it off. Okay, I'll make this brief. I live at 64545 Research Road. I've lived here for 33 years. I've been very involved with both. There's been two comprehensive planning processes in the time we've lived here. I am very opposed to this. Number one, Research Road is a private road. It's really an easement down at our end of Research Road. The way we access our property is through Lonza's property. It's an easement. So my question is, where is the right-of-way that everybody keeps talking about? I cannot, that's my huge question. We're here to talk about right-of-way, but Kine mentioned we'll use the cable lines, the power lines, and the water. Well, we have no cable. Our water is well water. And our power is overhead, which doesn't give him the right for underline access. So I, for one, am questioning where this right-of-way is, and so it shouldn't be allowed there. Number two, I think the attorney mentioned DEQ is not issuing septic permits out here, that's a false statement. We have a neighbor who's building on his 5-acre parcel currently, and he is going to be able to put in a septic. I've asked everyone on our street, all the septics are functioning fine. I just had mine checked to be sure. So the issue of, we are on the rim of Tumalo. We've always called the west end of Tumalo, up on the base of Laidlaw Butte as the rim, and then out Tumalo Road towards Putnam and Hopper as rims. The city, the bowl, is another issue. And I understand that the commercial properties need their sewer down there. We on the rims have very effective septic systems currently, and a lot of private easements, and so not the right-of-ways. The other point I wanted to make is we have a 2010 Tumalo community plan that is not set to expire until 2030. During that planning, the goal was to, quote, retain the livability of Tumalo as a rural, small town by ensuring safe and efficient public services and collaborating with the surrounding rural community. This vision statement is created to ensure that with vigilance and foresight, the unique rural character of Tumalo will be maintained and enjoyed by present and future generations. The number one issues expressed in that plan was the traffic situation as it pertains to Highway 20 running through town. The county should be focusing on that. Kine's new development behind Feed Company has added incredible traffic nightmares trying to ingress and egress off of Bailey. So this situation it's in violation really of the current comprehensive plan, and I would wonder if we're going to change that plan, what kind of official legislative amendment process are we making here to allow more density without first looking at the comprehensive plan, which was trying to maintain rural, and on the rims we have made our acreage 5-acre minimums for that reason. So those were my main points. The other thing I'll just say in closing is the attorney and Mr. Kine referred to the 1904 Laidlaw and how I would just like to refer people to the Oregon History Project, which talks about the ending of the Laidlaw project was they hung him in effigy because it was done without any infrastructure, and that's why we became Tumalo. So I'll just end with that, and I'm strongly opposed to this sewer system that's not needed on the rims. The commercial part of the bowl, maybe, but the rims, no. That's all I have.
Thank you, Ms. Long. I think the next person was, and I will butcher the name and I apologize, but Eve Tiernick.
Video on mute. Can you hear me?
Can hear you.
Perfect. So hi, everybody. My name is Yves Terling, and I live on 65670 Working Market Road in Tumalo. So my background is serving as a chief audit executive and the divisional CFO on a Fortune 500 company, which is the lens through which I had a look at this application. So more specifically, the legal entity, which applies for this right of way. In applying as a mutual benefit nonprofit corporation, the Tumalo Property Owners Association and its president, Larry Kine, seem to be in violation of federal and tax law, making them really unfit to make these kind of requests from the county. So the legal framework that I'm comparing against this federal and tax law, just to make that clear, and as you asked, Tommy. So during my independent review, which is based on publicly available data, I uncovered 3 major violations. The first one is the applicant, Larry Kine, registered his company as a homeowners association. Yeah. While in reality, we're dealing with a private sewer service company. I mean, Chris Kovac just called this out as a utility company. So I'm really confused here. Is it a utility company? Is it a homeowners association? Anyhow, this thing, however you look at it, it doesn't meet any of the criteria as set forth by the IRS in order to qualify for homeowners association tax exempt status. Second violation, we're not dealing with a nonprofit, since the Tumalo Property Association sewer operation is very profitable. But from a technical financial point of view, they are upstreaming all their profits to 2 companies which have not been mentioned yet today. This is Kine LLC and the Tumalo Investment Company LLC. And thus they're falsely trying to give it an appearance of a nonprofit who tries to do some favor for the Tumalo region. This is not the case. This is purely a nonprofit. Third violation. The applicant intentionally ignores the basic requirements of running a mutual benefit nonprofit corporation, which by law should be organized for the benefit of its members. Member rights in the association that he currently is already running beyond Tumalo Feed Company, these are crushed. Yeah, it effectively allows Larry Kine to run the operation all by himself, doing business with his own other companies that he's in control of, and primarily serving his own financial interests. And honestly, we don't need this to expand in all of Tumalo. So I would like to share my screen over here. Can everybody see this flowchart?
We can see it.
Yeah, perfect. So this is really depicting what is going on in this situation. So we are thinking that we're just talking about a relationship or a potential relationship being expanded to a homeowner and Tumalo Property Associations, again, a nonprofit. These guys provide the sewer service and the homeowners pay quite some money for hookup fees, transfer fees, etc. Yeah. In reality, so let's have a look at this homeowners association here, the nonprofit. So this entity was initially registered in the Oregon Secretary of State with the Oregon Secretary of State on January 1st, 2018, and it was named the Tumalo Homeowners Association. So the articles of incorporation show an election as a domestic nonprofit corporation, more specifically a mutual benefit corporation organized by its members. This is the case for any homeowners association in Oregon. Yeah. So how does the IRS define this? Yeah. So I'm reading now. A membership organization formed by a real estate developer to own and maintain common green areas, streets, and sidewalks, and to enforce covenants to preserve the appearance of the development may be tax exempt if it is operated for the benefit of all the residents of the community. Then on September 26, 2018, 9 months later, the name of this homeowners association was changed to Tumalo Property Association, Inc. No other changes were ever recorded as to the legal structures. For all intents and purposes, we are still talking about the homeowners association up to this day. And this is also the same company that's now, or nonprofit, that's making this application. The real kicker happens though a month after this name change, upon which the homeowners association issued its covenants, or CCNRs. Yeah? And this is really where a sleight of hand happens. While these CCNRs should normally cover community standards, as I just read you in the IRS definition, document claims TPA, which the abbreviation for Tumalo Property Association, to be an unincorporated entity to construct, own, and operate a private sewer system serving the lots behind Tumalo Feed Restaurant, but with the ability to expand to all of unincorporated Tumalo. So what we see is that most articles in these alleged covenants address funds flows between TPA, Tumalo Property Association, and these two companies over here. However, there's not even any mention of an appearance or a community standard. So I'm really confused over here what the link is with a homeowners association. In addition, I should mention that there's several articles in which, in there that crush the association members' rights, allowing Mr. Kine to just run the entire board and deny any homeowners' involvement. So this is certainly not a member-driven organization as it should be. Let's talk about the next violation over here, which is the claim that this should be a nonprofit. So in order to make use of this sewer system, any homeowner that signs up for it has to make hefty financial contributions. You can see that over here. There's $35,000 in hookup fee. Whenever a house changes ownership, there's transfer fees. Then there's the monthly and yearly assessments, potentially special assessments, and then a termination fee, which I'm going to be talking about later. So what actually happens is that most of this money actually immediately is flushed to Kine LLC and Tumalo Investment Company. The hookup fee is the bulk, $35,000, straight goes to Kine LLC, which only leaves the yearly assessment for TPA to run this sewer system with. So in addition, and this is really, how do we make this a nonprofit? Well, it's pretty simple. These guys don't own the sewer system. Kine LLC and Tumalo Investment Companies own it, and they extended the loan. And until this loan is actually paid off, this is only going to be the moment that, Tumalo Property Association is going to own the sewer system. So in other words, with passing on these huge fees over here and then milking the nonprofit here with most probably an egregious loan. By the way, this loan agreement has never been disclosed. So I'm really interested to see it and see what the duration of it is and the interest rate that is being charged. But by doing those kind of financial shenanigans, they can claim that this is a nonprofit, but it is not. And let me quickly show you over here, we're actually only dealing with one legal entity, and this is a for-profit corporation. I couldn't notice, and from a legal point of view, there is no legal separateness at all going on in here. This is straight from the Secretary of State website. 3 entities involved, Kine LLC, Tumalo Investments, and Tumalo Property Owners Association. Who's the president and the chairman? Larry Kine, Larry Kine, Larry Kine. Secretary, Larry Kine in case of TPA. Registered agent, it's always somebody involved with Larry Kine or an LLC he owns. And then the principal place of business is the same for all 3 entities. So, as a lawyer, I cannot detect any legal separateness over here. What I'm seeing is just one for-profit company. And I want to repeat here, it's a nonprofit applying for this. This is really confusing. Anyhow, let's talk about the last thing over here, and this is the violation of the member rights. The CCNRs, or the covenants, which I have a copy of, they set a new standard in restricting the rights of its members, so effectively rendering any semblance of a member-organized nonprofit non-existent. So let me show you a couple of the most egregious violations over here. So let's first talk about Article 6.4 in these alleged covenants. So the declarant, which is Kine LLC, retains full control over the association until all loans are repaid. As again, we don't know how long these loans are for, and I really love to get my hands on this. So as mentioned, the terms of the loan agreement, the duration, never been disclosed. So this could be years or decades from now. Even worse, in case of expansion of the system, there's going to be new loans issued, effectively starting this clock again. Net, this allows Larry Kine to be the sole manager of TPA, as we've seen, he's already the president and the secretary for decades to come. Article 4.2 then, which really goes in conjunction with what we just talked about, there's a requirement here for TPA to obtain the loans from Kine LLC for the acquisition of the initial sewer system, which they're kind of already paying back, but also for any expansion. So what this really means is that no competitive bidding for these people is allowed to any external parties or banks. So this is really, how he locks in total dominance of this board. Then Article 6.7, and this is really, I could cry over here, the voting rights. There's 2 classes of voting rights. So the regular homeowners, Class A, they get 1 vote per lot. This is really normal in any homeowners association. But then the kicker really comes with Class B, which is the declarant for Kine LLC. So until full control of the association is turned over to its members, see above, this could be, years or decades from now, Larry is entitled to 10 votes per lot. So effectively, Larry has 91% of the votes over here in this member-driven organization. Also want to point out Article 6.3. So in case a homeowner no longer wants to use the sewer services, a termination fee of 15 years of revenue needs to be paid as a penalty. Could you imagine disconnecting your cell phone service and having to pay these people 15 years of service? Anyhow, Article 6.1, this is where I'm ending my presentation, liability. In case TPA dissolves for any reason, and as Alice quoted, there's a history here of, major projects going bankrupt in Tumalo. The TPA nonprofit is succeeded by an unincorporated association of all owners. This is, from a legal point of view, this is really concerning, because in case the sewer system goes bankrupt, maybe through some, major event or a lawsuit, Mr. Kine's liability would be limited to his investment only, because he's protected through two LLCs. Now, the individual homeowner, they could be on the hook for everything, because they have unlimited liability in here, and they would be holding the bag. So I rest my case over here. I hope I make it clear that we have a whole host of other issues over here than what we're talking about today. I really struggle with the, this company not really being eligible to make this kind of requests anyhow, and I think that the county should give this to their legal department to investigate what is really going on over here, not just for this application by itself, but also for what is already going on behind Tumalo Feed in the existing homeowners association. I rest my case. Thank you.
Great. Thank you, Mr. Chairman. I don't have any questions for you. That takes us to Paul Granberry, I believe.
Yes, good evening. Can everyone hear me?
Yes.
My name is Paul Granberry, and I'm the president of Ben Research, Inc., and I'm representing our property at 64550 Research Road. Ben Research has been a proud member of the Tumalo community since 1975, and I appreciate the opportunity to provide some comments on the land use compatibility statement we're discussing tonight. To be clear, Ben Research supports the growth and improvement of public services for property owners in the area. However, as detailed in the written comments provided, we do have reservations regarding this particular LUCS and believe that a more comprehensive review and further clarification is needed before any determinations made on it. In fact, at the outset, Ben Research will request that in light of the implications of the novel issues with this for the broader Tumalo community and the time constraints we're seeing tonight, that this hearing be continued until a further date, or at least the written record be kept open to afford further opportunity to present evidence and testimony regarding the application. And if that's the case, we would request that the written record be held open, or we would propose that it be held open for 14 days for general, 14 days for rebuttal, and 14 days for final applicant argument. On the merits of this particular LUCS, we do have a number of concerns. First is the novelty of it. It seeks a blanket determination that any facilities proposed by this applicant are per se permitted uses in all application zones. But this applicant, has already been pointed out, is a private association, not a regulated public entity. It's not subject to the same level of oversight as utility service providers. Second, the LUCS does not meet the requirements for land use applications set out in the Deschutes County Code, Section 2208010. Specifically, the applicant is not the owner of the land subject to the LUCS. It does not have authorization from necessary private property owners, including Ben Research, which owns large segments of Research Road. It doesn't have the power of eminent domain. And the proposal is not for the development on lands owned exclusively by state or federal government. Absent one of these exceptions, it doesn't seem that the applicant should be able to submit this application, and the LUCS should be denied on that basis alone. Alternatively, the applicant would need to modify its proposal or otherwise correct these deficiencies, which requires a new notice and potentially a new hearing. Our third is we question whether proposed use could be categorized as a utility facility. Again, the applicant is a private association. It's not a, quote, public, private, or cooperative electric, fuel, communications, sewage, or water company, end quote, which are the only types of entities the county code states may own or operate a utility facility. Ultimately, it's not clear how or what extent this applicant would be regulated in any capacity. This presents a host of questions and concerns regarding the installation, operation, and maintenance of the proposed system, not to mention the rate structure for the proposed services and other legal issues. Fourth for us is even the prior approval for the applicant's existing wastewater facility must be modified before a decision on this current LUX can be made. Neither the prior proposal nor this LUX adequately describes the private wastewater system that is being proposed for the expansion. The prior approval also assumes that Laidlaw Water District would operate the system, but Laidlaw Water District, as you heard earlier tonight, has told the county and has also told the county staff that it is not affiliated with the LUX or the proposed project. And fifth, this LUX is premature for other reasons. Several other county agencies have expressed material concerns regarding this and the prospect of the land use decision being made at this time. For example, Deschutes County Road Department points to the ongoing Tumalo wastewater feasibility system study referenced earlier that should first be completed. In addition, Deschutes County Environmental Soils has raised a host of questions that we believe make approval at this time ill-advised. For example, what is the legal availability for the proposed sewage system connection points and how will that be determined? Which facilities will be required to connect to the applicant's proposed system and which facilities will be deemed to have the system physically available? What will the impact of the applicant's proposed system be on other construction install related permits? And then finally, there are questions surrounding the corporate and or private entities associated with this LUX, which already spoken of quite a bit, but including whether control of an important community service should be given to a private association of owners and affiliates, and what role of a potentially related entity such as Kind LLC may play here. To be clear again, Venn Research does not necessarily oppose outright permitting in applicable zones of underground utility infrastructure installed by regulated entities with rights of way that serve adjacent properties, but that is different from pushing the current LUX through land use and potentially other approvals without comprehensive review. Venn Research respectfully submits that the LUX should not be proceed until a host of procedural issues it's raised in this are first addressed. Even then, we believe that many substantive matters identified by both us and others here tonight and in the written comments we've provided should also first be reviewed and resolved. So I thank you for your time and your consideration.
And thank you, Mr. Granberry. I think that takes us to Nunzi Gold.
Hello, my name is Nunzi Gould, 19845 J.W. Brown Road. I have a mailing address of Bend, Oregon. My property is in rural Tumalo, outside of the Tumalo unincorporated community boundary. I appreciate the opportunity to weigh in. I wrote when I first saw the notice sign, the public notice sign, I wrote in expressing how I felt that the comprehensive plan that the county is currently updating was being hijacked, and it was not orderly development to be dealing through just an administrative permit sign-off on a LUX, that this definitely rose to the opportunity of a public hearing because there are numerous extraneous issues in addition to the work that's in the work plan and that's before the Planning Commission and before the public for weighing in. and that also includes the Tumalo Community Plan update. So I think this is premature, and there is another process that's already underway that needs to go through its full steps before ascertaining where we are at this stage. And I hope if the DEQ person is still in the audience, could you raise your hand, please? Because I think these are important things for DEQ to be hearing. And I know that Mr. Larry Brown, who wrote comments, has been away and isn't able to attend, but I'm hoping that DEQ, that has a local office here, will take into consideration these important community matters. So I just wanted to focus my testimony today on the fact that there are a number of private streets that are named within the mapped areas that are included in the application. Portions of Research Road, Laidlaw Lane, Otter Run, Winston Loop, all of the streets in the Deschutes River Tract, Alder Lane, Birch Lane, Cedar Lane, Elm Lane, Fir Lane, Juniper Lane, Pine Lane, and Hemlock. And in addition to that, there are a number of county rights-of-way that are not maintained by the county, meaning there's no service whatsoever for bringing a road grader down there or fixing a pothole down there. And I'll just read you a couple of those. Hopper, Putnam, Beaver, portions even of Cook Avenue, portions of Bruce Avenue, portions of 2nd Street, 3rd Street, Wood Avenue, Riverview. So I'm really curious as to on whose shoulders maintaining these roads is after a sewer system gets put in. And I think we need to really be thinking about how we're developing in an unincorporated community. This is not the city of Bend. This is not a city. This is a rural service area, and it is comprised of the original plat of Laidlaw, plus a number of other subdivisions that were platted before even land use laws. And currently the county is not taking on any public roads. County is outrageously underfunded and doesn't even maintain roads within the boundary of the Tumalo UUC. The other thing I'd like to bring up is, in addition to commercial zones, there are substantial land holdings in industrial zone and substantial land holdings in residential zone. And to understand what the carrying capacity is of those, what the needs of those are, just by virtue of having a count of lots. And so I know the focus of this is not supposed to be on the county's $150,000 road department RFP that they have put out, but I do think it is relevant because they talk about requesting 3 areas that might be considered for sewer. So it's very apparent to me that the Kine LLC sewer that is on a 3-acre leased land from Laidlaw Water District that I suppose has a property owners association that's proposing this whole thing. I'm just very concerned about having a private system be given some sort of autonomy to be providing an entire community on streets that aren't that aren't even county maintained, and on streets that aren't even public streets. These are private streets. So again, I think the cart is really before the horse. It's pretty simple to me that the Lux should be denied. It's not compatible with the current comprehensive plan. It is years away from the current comprehensive plan that is already underway. And, examples of what that are in 2 evenings, the Planning Commission is moving along with the work plan on things that are within the county comprehensive plan. So the other really big thing for me is I don't believe until this was elevated to requesting a public hearing that people within the boundary were even informed, or that the county even recognized the need to be notifying people within the boundary. And there is another group that I think should be involved, and that's Oregon Park and Recreation Department. I think it's important that that the current system that is serving a dozen or so houses, maybe they're 20, I don't know, Mr. Kime can tell you how many he's built behind the Tumalo Feed Company. It's important to me that these be, sorry, let me just kill my phone. Sorry about that. What's important to me is when the next power outage goes out, that there is a backup power system for this sewer system that the county and DEQ have already put into play. And, we've had hailstorms in Tumalo, we've had power outages in Tumalo, and right now, individual homeowners' powers are what pressurize this main line, whatever the dimension is, up 120 feet to its current location. And if anything, I believe there is a need for our community to be having a more holistic view of what is in place today. And I think it's very premature to be expanding this thing to the Tumalo unincorporated boundary. And I'd like to share with you that I am interested in the ecology of our community. And as there has been development, there also is a loss of the rural nature. In other words, Mr. Kime's development has cut virtually all the trees that used to be on the property. So with urbanization comes a change in the environment. And I think it's important for us to be including that in, because that's not what's written into the rural nature of what's in this rural service area, this unincorporated community. So do you have any questions, Hearings Officer Brooks?
I do not have any questions for you, Ms. Gould.
Okay, well, I would like to also have opportunity to respond to any new materials that are submitted. What's important for the rural community of Tumalo is to have a safe intersection in Highway 20. And I'm kind of offended, frankly, that $150,000 of road money gets put, towards investigating an RFP for sewer instead of prioritizing the safety issues that have been long needed in the community of Tumalo for basically the 30 years that I've lived in the area. And I think I just think that we got the cart before the horse here. And at this stage of the game, it's pretty clear that it's not in compliance with the comprehensive plan. And that process should be completed. And that certainly is not going to happen in the next 150 days. I mean, the RFP only goes out, and they expect to get that signed sometime in March. So, and that's a multiple multiple timeline process. So I don't know if the staff has put that into the record, but I do think it's worth your being conversant on that issue. Thank you.
Thank you, Ms. Gold. Brings us to Carla Langford.
I believe Carla Langford is actually logged in under a different username. If Carla Langford's still attending remotely, can you use the raised hand feature now? And I do want to acknowledge separately, Ken Katzeroff has his hand raised, but I don't believe that's the same member of the public that was going to provide testimony tonight. So Hearings Officer Brooks, we're not seeing Carla Langford on the Zoom attendance anymore. How do you want to proceed?
Then we can move on to Don Lillis.
Am I there?
Can hear you.
Okay, thank you. My name's Dawn Willis, and my address is 19960 Cedar Lane, Bend, 97703. I have just kind of a bullet list here of comments I want to make or input, and some are redundant, been addressed by many of the panelists previously tonight. But first of all, my concern is I am wary of the Tumalo Property Owners Association. Never met the people, but just by virtue of having read the user agreement that is the sewer user agreement, when I first read that, my first comment was, wow, that's harsh, because it's the costs, as I think Eve's Cheerlink said, the costs are, they're unopened, but they're open-ended, is what I should say. Cost after cost after cost for the sewer, for the agreement. I am interested in the RFP and the proposal for the county to do a study. I know when I researched the Terrebonne one, that the Terrebonne feasibility study included things such as timelines and end user costs and phase build out options, the different treatment sewer facility options. And so that would be something I would much prefer to pan out and see than the sewer facility that exists now just be dumped in my lap, or here it is now, this is what you will use if you ever hook up, and again, without any initial input. I've lived in Tumalo for 40 years, and I'm one of those that lives down, I call it the hole, and one of you said the bowl sounds better, but it's downtown Tumalo on Cedar Lane. And again, someone's mentioned this before, alder, birch, cedar, juniper, pine, elm, fir, we are private roads. We do our own paving, our own plowing, our own graveling, our own everything. So there's always been that quandary of, who would help, how do we get help when we need it, or because they are private roads. That's a concern I have about the right-of-way easement. I'd like to clarify a point that was in the Lux statement. I was kind of maybe nitpicky when I submitted something online to Caroline about the Lux did have some inaccuracies in it, and I think that's what first kind of ruffled my feathers, because I didn't think due diligence was necessarily done when you say that there are no septic systems being allowed in Tumalo any further. That is incorrect. I'm watching a house being built down the street from me. I watched a house be constructed in 2020 and 2021 or 2019, but they're granted they're not the traditional leach line septic systems, but they are allowing the alternative septic systems in some properties in Tumalo. So to clarify that. I have another issue of growth in Tumalo without infrastructure concerns. I'm not anti-growth, but if hearings officer, if you've never visited downtown Tumalo, when there's traffic parked on both sides of Cook Street, and there's blind spots, you can't see beyond corners, and you can't pull out on Highway 20, and you can't turn off of the corner of Klein Falls and Tumalo Road and Cook Avenue because there's so many cars parked there because they're floating the river in the summer. We've got infrastructure issues that are in dire need of consideration. No sidewalks, no street lights, no curbs in many of the residential areas, and so that to me is a priority. Growth will bring new sewer lines, would bring growth, more commercial buildings downtown, which would make the congestion and the infrastructure issues even more difficult to deal with for those of us that live here. And then my last comment is, I would like clarification, or here's a question I have. Oops. Excuse me. I recognize that there's that the Lux versus further land use planning issue is based on major facility versus minor facility, because one is allowed outright and one has more consideration that has to be dealt with. That's how I read that, and I'm questioning or addressing what I thought I read in the initial in the Lux that's online. I believe I read, and if I'm wrong, please clarify, that a Lux was submitted initially, but it was pulled from Mr. Kine or his attorney. It was pulled because they were going to approach their approval in a different way. And how I read it was that there could be a possibility of have pumping stations at the sewer facility site, if that's a possibility, versus the way that Mr. Kine or his attorney explained that it would be all fine for us to have the pumping stations within the tanks that sit on our property, because then that's a minor facility. But if you had the pumping devices up on the hill where the treatment plant is, it's a major facility. And if in fact, I need clarification. I read it that they pulled their first Lux because if you do it with the minor, of course, you can have, it's easier to get it approved. If you do it with the major, having the pumping facility up on the hill and not within the confines of the homeowner's property, that it's a easier fix, I guess is what I'd like to say, I mean, for lack of better words. So I need clarification on that, okay? And that's my comments. Thank you.
Okay, thank you, Mrs. Lillis. Next on our list is Patrick McGowan.
Patrick McGowan, if you're still attending remotely, can you please use the raised hand feature? And I do want to acknowledge that a Megan user has their hand raised currently, but that was before we called Patrick McGowan. So Hearings Officer Brooks, I'll leave it up to you whether you want Megan to be promoted.
No, let's stick, since we're in the opposing part of the proceeding, we'll stick with Mr. McGowan. I think he was the one logged on as Linda Ferguson.
It doesn't appear he's on, or Linda
okay.
Anymore.
Okay. Then Gabriel Kohler is next.
All right. Hopefully everyone can hear me and see me.
I can hear you.
Awesome. Thanks. My name is Gabriel Kohler. I live at 19925 Juniper Lane. That's one of the many private roads that people have been talking about. I'll keep my comments brief because most people have touched on them. And also I wanted to stick to kind of the task of, addressing the concrete criteria of the application and the code. It's somewhat difficult to do when the application is like, we're going to pump poop uphill and everyone's going to be happy about it. Like, the application is very ambiguous, and it just doesn't have a lot of concrete examples. If I was going to help the Tumalo community that I once lived in, I would maybe like have a meeting, or I'd maybe say like, okay, this is how many houses I think will be on it, so we need this diameter pipe. But none of that is in the original application. So it's difficult to say, how does this fit into the code? And I was kind of just left having the same questions that Caroline addressed in the staff report, where we're like, what is this thing? I don't even know. It doesn't even say what it is. So I have a lot of problem with that ambiguity, I guess. The second part of my concerns fall into maybe the same basket that Eve's concerns were, which is basically centered around the Tumalo Property Owners Association. I'm not as adept at going through the tax code as Eve's is, but I did call some friends who are in Larry's new development over there, and I said, what's it like being part of the Tumalo Property Owners Association? And they couldn't really explain to me how their systems worked. And they told me they pay $90 a month or 90, whatever, not important. And I said, have you ever been to a meeting? And they said, no. And when I look up the Tumalo Property Owners Association, I'm left with the same conclusions Eve has. Like, it's just Larry Kine LLC. So you're like, I don't know. That gives me a cause for concern. Doesn't seem like the intent is to help out the residents of Tumalo like myself. I have further concerns just having a public utility provided by a homeowners association, specifically one that's ultimately a private business. And these concerns include the regulation of the Tumalo Property Owners Association, legal recourse I may have as a member of it. If we were signing up for a sanitation district, there'd be some regulation around our rates. None of that exists. And then lastly, as Eve mentioned, if the whole thing goes belly up, what am I stuck with? Basically, it's not a public utility. And some of those concerns kind of get into like this: is it a minor facility? Is it a utility facility, or a public utility facility? What size is the pipe? That kind of stuff. I think it's a little different. When Chris Kobach says, "Oh, nowhere in the public record has there been this problem. We put in this 36-inch pipe, and we only want a 4-inch pipe." And you're like, "Well, who put in that 36-inch pipe? Was it a private developer putting in a public utility to an entire district of already existing residences?" My guess is probably not. So I think the concern is more where is this coming from? Basically, are more of my concerns, and it just doesn't seem beneficent to me, I guess, is the problem. And I couldn't nail it down in the application or in the materials provided to even say what it was or is it legal or not, kind of thing. That's all my comments. Thank you.
Thank you, Mr. Kohler. I think we said Linda Ferguson was no longer on. So the next opposing one would be Jessica Kiernan. Did I get that right?
Jessica Kieran, if you're still in attendance remotely, can you please use the raise hand feature? It doesn't look like you're currently displaying on the list. No raised hands. Hearings Officer Brooks.
Okay. And I think that finally takes us to the folks in person who are in opposition.
And there's only one person remaining that has signed up to testify. That'll be Paul Dewey.
Oh, Mr. Dewey.
Thank you, Mr. Hearings Officer. Please let me know if you can't hear me.
I hear you just fine. Thank you.
The mask. My name is Paul Dewey. I'm an attorney representing Central Oregon Land Watch, address 1539 Northwest Vicksburg. band 97703. I've submitted comments, written comments just now. And so I thought I might address some of the issues as I've heard them come up this evening. I was particularly intrigued by the various councils' experience or not experience with Lux being treated as a legal matter. I know of several cases, in fact, maybe it happens more in Deschutes County than elsewhere, but Curl versus Deschutes County was a fairly prominent, somewhat recent case that went to LUBA, and I've had a couple of others. It's a long-standing use. Kevin Harrison, when he was the director, utilized that, and there's clear authority for it in DCC 22.16.010. Parents, capital B, gives discretion to the department head to find that that a Lux should be elevated. And in this case, I think it's particularly appropriate here because of the potential impact of a sewer system that covers the entirety of the unincorporated community of Tumalo. To Deschutes County's credit, it treats unincorporated communities quite seriously and has done plans for the unincorporated communities, and those plans are incorporated in the comprehensive plan of the county. If I might read just a little bit from the Tumalo Community Plan, one section is that describes it as, quotes, an integral part of the Deschutes County Comprehensive Plan. It constitutes an official chapter of the county's plan and can only be changed through an official legislative plan amendment process. And if you look at the Tumalo plan, the community plan that was done over a decade ago, it goes to 2030, it identifies a number of issues to be addressed. Public outreach, as was done in this case, fortunately, and is being done in Terrebonne, is something that the county should be proud of. And they take this seriously. There is no wastewater treatment facilities are mentioned as many as other issues, but there is certainly no decision authorization for such a facility in that plan. And frankly, I think it's Division 22, OAR 660, Division 22 for unincorporated communities, requiring what the county is apparently thinking of doing with their RFP, so that unincorporated communities have public facility plans, or that the county will do studies on them. Because as one person mentioned, what's going on here really is a cart before the horse, and it was almost an Oklahoma land rush experience in December, apparently, when the county was issuing the RFP and Mr. Kine was getting his application in for a sewer a couple of days before the county sent out his RFP notice. The testimony this evening, I think, is very instructive as to the practicalities of not knowing exactly what this system is made up of, or how it would operate for the entirety of the system. There has been some comment that it's a question of minor versus major, and because it's a small pipe, it must be minor. With all due respect, I think the reference to something being major is about function, not just size. And when you're talking about a community-wide system, this is a system that would apply to the entirety of an unincorporated community. That in itself constitutes something major. This is not a minor impact, a minor installation And the Tumalo Community Plan really pointed out the dilemma, and this is what needs to be decided by that community. And actually, one person earlier spoke, I thought quite well, a business person saying she could really use a sewer, but she didn't necessarily want it for the residential community, because as that plan discusses, they want to keep the rural character of Tumalo. But they also want to help out their businesses. But that sort of analysis occurs in the context of a feasibility plan or a public utilities plan under Division 22, not in a quasi-judicial application like this, let alone in the form of a Lux. Because it's a land use matter, I think you really need to deny the application because of a lack of information. There are a number of different land use zones, some allowing for sewage system or utility systems, others not, and we don't have any of that information in the application, providing us with the criteria and then the proof that the criteria are being met. And I suppose, well, I joined in the request for the 14 days and 14 days, but really would like to bring home that what is needed here is a legislative plan amendment, unless the applicant wants to move forward with, by showing what should be in various zones and how the criteria of those different zones are met. And finally, the comment by Mr. Kind to the effect that it seems like it would not be fair or appropriate that some zones might have a sewer system and others not, but actually, read the community plan. There's that, or the earlier testimony of it might be appropriate in the industrial area, or in the, near Bend Research, or in the commercial area, but not appropriate in a residential area. So I'll leave that for now and provide comments afterwards, unless you have some questions.
I don't. Thank you, Mr. Dewey. I appreciate your comments. So, Ms. House, have we gone through the entire list of people who signed up to testify?
Yes, we've gone through the list. There are 2 hands currently raised. One has a username of Megan, and then the other is Ken Katzeroff.
Okay, I believe Ms. Pana already testified. That's Megan. So I'm going to assume that she may have a procedural question, but we're not quite to that point yet. So, but the second name, I didn't notice that on the list anywhere. So we should ask that person if they are wishing to testify.
All right, he's being elevated as we speak.
Can you hear me?
We can. Are you hoping to testify on the application?
Real quickly, sir, if that's okay.
Sure.
Ken Katzeroff for the record, 1420 Fifth Avenue, Seattle, Washington, 98101, Suite 3400, importantly. I apologize I was late this evening. I have no particular interest, so I wouldn't have signed up for or against. I would be a neutral comment, if anything. And the only reason I'm here is because I'm a giant nerd and I watch too many land use hearings as a practitioner myself. And I just wanted to make one quick observation, which is as I joined on to the end of Mr. Kobach's comments, he made a comment that they were unable to find any other utility that had to go through a land use review process. And I'm reminded of way back, my first job as a lawyer ever, although I had not passed the bar yet, so I wasn't technically a lawyer, was helping Central Oregon Irrigation District with a text amendment in order to hopefully do a pipe as part of a hydroelectric facility. And although that is in Title 19 of the Deschutes County Code, different than Title 18, which is what we're going through here, that was certainly a process that was a utility and required a land use review process. And so I don't know, again, I don't have a particular interest in this. I have not read the staff report or anything of that nature, but I just wanted to make the comment that Mr. Kobach probably didn't know that would have been an inaccurate statement. Deschutes County has certainly required land use review for utilities within the county, maybe under a different zoning district, Title 19 in particular, but they've certainly done that in the past. So that's the only thing I wanted to say. I felt like I needed to clarify that the county, I particularly experienced it, has required it. And so it's the same set of definitions, I believe, that they applied in Title 19 as Title 18, but I just throw that out there. And I appreciate your time. I'm happy to answer any questions.
Thank you, Mr. Katsaroff. I don't have any questions for you. So I think that takes us to the applicant's rebuttal. So if Mr. Kobach and his client want to be re-elevated, please do that.
Chris, are you going to go, or would you like me to start out? It will be, I guess, under state law. I'm going to keep my rebuttal somewhat brief, and we'll do a more detailed response in writing.
Mr. Kobach, sorry to interrupt. For some reason, I missed the first maybe 5 seconds that you were speaking. I think the video was coming on. So if you don't mind, just I want to make sure I didn't miss what you said.
Sure. Well, I was just saying, since somebody else requested the record to be left open, and I think the statute mandates that it be kept open, I'm going to be a little more brief, and we'll submit written testimony in that first period. I want to start by saying, I think the issue here is really, really narrow. This is a land use compatibility statement, and the question that we asked the county to answer is, was what we proposed, the extension of these lines, was it compatible? Was it consistent with the land use regulations in the comp plan? A lot of the comments we heard were about future permitting, and a good example of that is private streets. Now, the question is this proposed use compatible or consistent with the land use regulations? It's irrelevant whether it's public or private. That question could be answered, yes, it's compatible, it's consistent, but it doesn't mean that a pipe is going to go into a private street without the owners asking for it. And so, like I said, there's two components. In the public streets, if it's consistent with the land use regulations, then within the public streets, there's a permitting process, and every utility company has to go through a permitting process to work in the public right-of-way. You have to repair the road. It's a road permit. Now, if it's in a public or a private street, first of all, then there would be authorization. If any review is required, any grading permit, any permit, then the owner has to authorize that. We're not suggesting that this determination of compatibility or consistency allows this pipe to be put anywhere. It's just the statement that it is consistent, and therefore that sets forth what permitting in the future has to be accomplished. And if we led people to believe that every property in Tumalo needs to hook up, we never intended to communicate that. If there are existing septic systems that work, we presume that they can continue to do it. Nobody's, as Mr. Kine said, this isn't set up to force people to hook up to sewer. It's an opportunity. This was something that was a need. There were, and nobody's denying this, there were a lot of properties that did need an alternative to septic. And we've heard from some of those people tonight. And the county wasn't doing it. There was nobody there to provide that essential service. So Mr. Kine in this association that he helped get going was there to fill that void. And a lot of work was done. And we assumed the county deemed it consistent with the regulations because we've never had to go through this before. And now that there's this proposed expansion to provide that opportunity for other people, now we're hearing the county come out with a lot of criticisms and questions about it, and people are getting what we think is misinformation about having to hook up. It was never the intent. The intent was to give people an opportunity to connect. Now, we heard a lot of testimony about nonprofit, et cetera. None of that is relevant to the criteria. The only criteria is this consistent with the land use regulations. And I think that issue gets down to, is it a utility facility or is it a minor facility that's outright permitted? That's really the core question. And I'm going to talk about, I think Mr. Dewey had some good comments on that, and I'm going to briefly respond to that. But I did want to clarify one other kind of big misconception, and that is that somehow the first Lux was pulled because there was a change in the plan. That's not true at all. I was involved in that. What happened, there was a Lux submitted that really didn't have a lot of detail. And so in communications with county council and other people at the county planning, the county suggested that to give them more information so that the county could respond to the Lux, we would give them an explanation of really what are you trying to do. And if you've seen the full Lux, the one that we're here on tonight, it's very detailed. We gave the county what we thought the county wanted as far as how does the system operate? What are the facilities being proposed? Are you proposing other facilities other than pipe in the right of way? So that was the only reason we withdrew the first Lux, so that we could give the county what it asked for as far as the level of detail in our Lux. So that's that response to one of the comments of Ms. Lills. The other comment I wanted to talk about is there was a comment about, I think it was, where is this coming from? In other words, if the 36-inch interceptor line was done by one entity, it seemed to be, the suggestion was it's okay, but because this is being done by a private association, somehow it's different. I just wanted to submit that if the question is under a Lux, is it consistent with the land use regulations? Our point is it doesn't matter who the user is. It doesn't matter who's installing it. The question of consistency and compatibility doesn't depend on who's doing it, or at least it shouldn't. It shouldn't be deemed compatible if the county is going to do it and incompatible if Mr. Kine is going to do it. We have to be on the same playing field because we are subject to the same land use regulations. And that brings me to another point, which is the timing of this. There was a suggestion that Mr. Kine is racing to beat the county. That is, the opposite is true. This system has been going for years, and the plan to expand has been going on for a long time. In fact, that first Lux, I think, was submitted about a year ago. We believe the reverse is true. It looks like now that somebody else is providing this service, the county is now trying to get in the game. And we didn't know about that until after we submitted the Lux. That was a surprise to us that the county had sent out that RFP for presumably a different system when we were proposing one that we thought was a great opportunity and alternative to septic systems. So it wasn't that we were trying to beat the county to anything. And I think one question that has never been answered is, even if the county were to do a system, it's got to go through the same questions. How would the county extend services into private roads? How would the county develop a system that allows people to join and allows people not to join? We believe the private system offers more flexibility, and we think if it's a public system that the county does, they're going to require more people to join, because then it's truly a public system and the state regulations apply. We're going to address the state regulations, but what we believe is the regulations would allow flexibility for some people to join who want to join, and other people who have septic systems that work and aren't concerned about it or aren't having problems with failure, they can continue to operate under their septic systems as long as they want. Now, I heard a comment about inconsistency with the community plan. I've read the plan. The fact that the plan doesn't talk about a community sewer system or a private sewer system to fill this need, I don't believe that makes this inconsistent with the comp plan. I just think the comp plan doesn't mention it. And should we wait for this comp plan amendment to solve this problem? I don't think there's any reason I've heard that would compel a community or a group of people that need this service to allow this system to expand now while this process is going on. The fact that the county may be looking at another system, well, that's fine. That's a separate process, but I don't think it's a reason for the hearings officer to say, therefore, this one has to be inconsistent. I mean, it's the same question: is this a minor facility that's outright permitted, or is it a utility facility, which is a major structure as the code defines it? That's the limited issue. Now, Mr. Dewey raised some good questions, and we don't disagree that the county, as I said, I don't disagree that they have the right to elevate something. And I know that land use compatibility statements are oftentimes land use decisions. They go up to LUBA. I've seen those. I'm not debating any of that. The concern I have about his testimony really was he talked about an application. And that's what I started talking about, is we didn't file a land use application. We filed a land use compatibility statement asking for a very simple question to be answered. And as I said, we elaborated on the detail as the county requested so that it could make that statement. And we believed it was going to be a staff decision at first. And then the county decided to elevate it, which, again, we're not quarreling with. They did it. They probably have the right to do it. But this is not a land use application that we filed. We filed asking a very specific question. That's the question you're going to have to decide is this a minor facility for which road permits and other lesser permits will allow it to be expanded in the future? Or is this a utility facility which then triggers different reviews, perhaps, and in some cases eliminates the possibility of expansion to certain properties? So that's my comments. I'll let Mr. Kine pick up after that.
Okay, but do please stay on so we can adjust the procedure in a minute. But Mr. Kine, if you want to go.
I won't take very long by any means whatsoever. Mr. Kovac certainly commented and gave you some reasons about why we pulled the other locks. And, the process here, the main reason we turned in like a master plan showing the entire unincorporated community is the process that the city has taken on this is very cumbersome. The process that we had when we did our first system was amazingly streamlined. My approval through DEQ was like 2 or 3 weeks. I mean, it took me months to provide the documentation to give to them for the system and all of that. And we had lots of professional engineers put together that treatment facility and all that. But the process of getting it approved went very quickly, including the luxes needed for the treatment facility up on top, as well as the luxes for the, not transmission lines, but the collection lines going through on Bailey and on Wood Avenue and on Strickler and all of those that they've done in the past. So the reason we did a master plan was so that we could have it all done so I didn't have to go back through this again. Are we building that whole master plan day one? Heavens no. I mean, I'm going to be funding this all out of loans, out of my own money, and the only hope to ever go get paid back any of that is by people hooking up. And so I am not going to go have this system go build out through everything. It's going to be a system that grows organically for the people that want to hook up to it. Now, I already know that there's 7 or 8 people right over there by where the bite is, and some other businesses over there that want it. That's where it will go to begin with. If other people say that they want it, then it will expand that direction. But it's not going to be a full wide. The reason the master plan there is to have that step over and done with all at once. Will it ever go up on Research Road? I don't know. If somebody wants to hook it up and it's cost feasible for doing it, yes. If it's not, no, it won't. Will people down on Cedar Road want it and get it? If they want it, yes, and it's feasible, we'll run it. If not, nobody wants to hook up, it won't go. And so it's very, that's the reason you see this master plan, is to get this formality of a Lucas out of the way day one. That's why you're seeing such a big plan, and I can certainly understand how that has caused some uproar in the community. You know, as far as the gentleman that went through the whole rigmarole about how Kine LLC and Tumalo Property Owners Association and, you know, whatever is, I mean, he's out to lunch. I mean, I certainly can go provide the nonprofit tax returns showing that Tumalo Property Owners Association is a nonprofit and doesn't make any money, and it has a significant amount of debt to it. That is my money that's completely at risk, trying to go help and do a good thing. First and foremost for my development, which was for profit. I understand that. And that was done. Now at this point, I'm doing it out of the goodness of my heart to go expand it through the Tumalo community. And there's a lot of folks that aren't here today that were looking for that expansion. And those are the people that I'm trying to work with to get it expanded. You know, the other part that I think Mr. Kobach talked about it, and I think everybody's confused, is they think this is the end game. They think once you say, yes, it's compatible, which I certainly believe should be done, or else it's a slippery slope for anybody wanting to go do a sewer system, expand Laidlaw Water for expanding their transmission water lines, for power extending theirs. Wherever it is in the county where somebody wants to extend utilities, this is a slippery slope if this is denied. So what I was going to say is there's a lot more approvals to go on. There's a lot more oversight. The road department is going to go review those plans. DEQ's got to go and take the detailed plans of the collection system and review all of those and approve them and make sure that they're safe and they're not going to have a problem, and that they've got backflow devices and they've got, you know, the proper things for in the event that the power went out. I mean, we designed the whole system to handle all that. Those are all things about people that are just plain and simply naive to the system, that experts have to go review at a later date in an official review process, be it the road department and DEQ, before this system can go in place. We've done it before, we can do it again, but they are just misinformed or not informed at all and naive to the whole process. And then the last thing, the last thing was the gentleman from Seattle that was sitting there. He just didn't hear Mr. Kobach. I mean, what we said was we asked for a public records request for any projects for the extension of utilities inside of right-of-ways. We got none. What the gentleman from Seattle, Ken, was talking about was not inside a right-of-way. That was inside easements that were major canals, and those were major transmission lines for hydroelectric facilities, and going and changing that were not inside of right-of-ways, and that were major components for collecting the water to go take them to hydroelectric plants. Vastly, vastly different. He just must have came in at the last minute and didn't hear it correctly. Anyway, that's what I said. I think we'll be, providing some more things, but I think, in reality, there's not much more to provide. I mean, the code is very specific. It's been approved lots and lots of times. And there's actually the vast majority of utilities never even need to get, a land use compatibility statement because it's a given that you can extend water. I mean, it'd be great to ask Dale with Laidlaw Water, has he had to go through any of these types of jumps to extend the water to the whole community over there? I already know the answer because I've asked him. It's no. So anyway, thank you very much for your time. Sorry it's gotten to be such a convoluted process here with a bunch of people that, really are, the county kind of caused it by trying to make us go put in a bunch more information that just made it more confusing. And so I'm sorry for that, but I think the decision is pretty clear on what needs to be done. Thank you so much for your time.
Thanks, Mr. Kine. I do have one follow-up question from you, just based on the information you just provided. So, as I was reading the logs or the materials you put together for that, it does have the entire master plan that shows everything. What you just testified to was that maybe you're going to be only pursuing a portion of that. So, what is the scope of the permit you're actually requesting from DEQ? Is it to have a wastewater plan for the entire Tumalo area, or is it for a portion of that area?
Yeah, that's a great question. I'm really happy that you asked that. So the system that I currently have and up and operational was permitted for a specific amount of volume of wastewater, up to about 20,000 gallons. Anything beyond that is going to require additional public hearings and approvals. And so right now what I have is around the ability for 8 to 9 additional hookups under the system that I currently have. Anything further above that is going to require additional approvals for DEQ to expand that treatment facility. And so what I was doing on this, for this Lucas, is they also need a Lucas, not only for the treatment facility, but for wherever you're going to go run the pipes. They required that for me on my original one, where I put the treatment facility on the Laidlaw property that we leased. And they also required that for the property where the Tumalo Feed Company is and the houses that were built, showing where we're going to run the lines. They quickly approved both of those, by the way. And so instead of having to go through this process, multiple times, what I was trying to go do is saving everybody's time and energy, is to show a master plan that could potentially be built out at maximum capacity at a later date, in the event that every single person down in Tumalo eventually wanted to get hooked up. That's obviously not going to be the case, as you heard from people tonight. There's going to be many people that don't want to, and there's going to be many places like Bend Research and all that they're up on top where my treatment facility is. They have no need for a sewer treatment facility. They're up where my treatment facility is and the leach lines are at. And so the likelihood of that sewer being expanded up there is almost slim to none. There's other locations where people might not want it, where their septic systems are working properly, but I just incorporated it all so that it'd be one and done, that in the event that we needed to expand the system because people decided they wanted to hook up, they wanted the opportunity for sewer, that step would now be done, and it would be just a matter of the approvals of the DEQ and the road department to extend those lines.
Okay, so let me just ask one follow-up to that, though. So that helps me understand why you've checked both boxes, that it's both for a new permit and a permit modification. The permit modification relates to your existing treatment facility, which you said is capped at a certain gallons. And so the increasing that is what you need the permit modification for. And then the new permit portion is for the collection lines that would be in the rights of way or in these private streets.
Yeah, I'm not sure exactly how DEQ goes and looks at that. If they see that my one system is just an expansion, even though I'm just extending, collection lines. And then once I got to the maximum capacity of the existing system, where we went in for an expansion, assuming people wanted to hook up to it, and there was enough demand, that we would put in for an expansion or another system that basically mirrored this, because these are kind of modular. So you can kind of just go do a module and go add another 20,000 gallons or another 10,000 or another 50,000 gallons to the system. And so not knowing how DEQ would look at that in the future, I wanted to have both of those checked off. So once again, just to try to streamline the position in case DEQ required that.
And so the intent, sorry to interrupt, but so the intent, even though you may not construct it all at once, your intent with your application to DEQ is to still have it cover the entire area.
Right. And like I said, basically, on the system that I already put in, it went through commercial zone and residential zone in the Tumalo area. It did not go through industrial zones. I will admit to that, but it did go through the residential and the commercial zones.
Okay. Thank you, Mr. Kine. Mr. Kovac, the question I still had remaining for you, it sounded like you were okay with an extension of the written record. There were multiple requests to do that, not just, but I guess there were specific requests for basically what I'll call a 14-14-14 period. I don't know if you had a comment on the duration of the record extension.
Well, no, I think the statute requires 777, and we could comply with that. So if you feel 14 is more appropriate for other participants, I'll just leave that to your decision making. But we don't oppose the open record because I think it's required under 197.763. As far as the 14 days, I think that is a little discretionary. I think only 7 is required. We can get by with 777. So I guess the decision for you is, do you want to allow 14, 14, and 14?
Okay, and I'll thank you for that. I'm going to put one more question back on you then, because the way the county code reads is that the record extension does not count towards the 150 days unless the applicant either requests or agrees to that. So the reason I would like to know your position on this is to understand maybe the full implication of the impact on the 150-day clock. If you are agreeing to, for example, the 777, I think that automatically extends the 150 days by 21 days. If you are not agreeable to the 14, even though I have the discretion, I do think to leave it open that long, I think it would only extend the 150-day clock for the period that you did agree to. So that's why I'd kind of like to get your position on if 14 days would be appropriate, because I don't feel strongly in terms of how much time people need. I think I've got a lot of information in the record already. I think the question here is very narrow and can probably be answered. I hope that the parties provide more information, but I guess again, I'd like to get your position on if the 14 days would be acceptable to the applicant.
Well, first of all, I think under the statute, 14 of the 21 days do not count. I think the 7 days does count, but we can deal with that later. That's just my reading of the statute. But we're going to go with the 777, and we're not going to agree to 14 to extend the 150-day period. So that extension, if you were to go to it, would not be with our consent.
Okay. Thank you for clarifying that. Okay, I'm gonna have staff come back up really quickly.
I did want to note, Hearings Officer Brooks, that Megan still has her hand raised. Megan P.
Oh, thank you for that reminder. Yes, I guess we could elevate her and ask her if she has a procedural question. I'm not inclined to take additional testimony because I think we're about to keep the record open for a small period of time. So Ms. Panna, do you have a procedural question? And you're on mute if you are trying to talk.
Hi guys, my name is Stephen Pena. I'm actually Megan Pena's husband.
Okay, did you have a procedural question?
Not necessarily procedural, but it was just something that hadn't been mentioned tonight. And it was pertaining to our low water table here being down in the valley. And in the last 10 years, I've noticed anybody that's watched the news has seen how we've had salmonella and all these failing septic systems in the area, causing, poor water, drinking water.
Sorry to cut you off. It sounds like you're wanting to provide testimony. Is that?
Sure. Yes, sir.
Since we've gone through a number of hours here, and we've kind of already got through the portion where people are testifying, but I am going to leave the record open for a time period. So I would ask that you just provide your comments in writing through that mechanism. Thank you.
You got it. Yeah.
Okay, back to you, Ms. House. I wanted to give staff an opportunity to respond to anything that if you wanted to.
There's nothing necessarily I want to respond to tonight. The county staff do want the record to be left open as well. So a 777 minimum would be our recommendation. And I also did want to note that additional public comments have been submitted but not uploaded into our electronic system. So those are officially received, just not available, as well as Eve Tiernick's slide deck has also been emailed to me and is in the record. So I just wanted to acknowledge that at tonight's hearing that those materials have been received.
Okay, so I think for now, I am going to leave the record open, but only for a 777 period. And Ms. House, I think you might have instructions for participants for how to comply with that. But before you get to there, I'll just to make it clear that the first 7 days will be for any participants to submit evidence, argument, information. The next 7-day period is for rebuttal only with no new evidence submitted. And then the last period, 7 days, is just for the proponent to make a final legal argument with no new evidence with no new evidence. So with that, Ms. House, do you have instructions for people on how to comply with that?
Yeah, I'll try to be brief, but just any submittals should be to my attention. So Caroline House with the Deschutes County Planning Division. Any electronic submittals that exceed 20 pages, include color figures, or need to be printed on a sheet size greater than 8.5 by 11, need to be submitted as a hard copy. You can send them electronically to meet like a deadline, but make sure you at least follow up with the hard copy submittal. The other thing to note is the county does not retrieve information from other websites or personal cloud storage service. So any material you want entered into the record needs to actually be presented. And also note that don't wait till the last minute to submit anything. Sometimes things, if you submit right at 3:59, we may not receive it, the county servers may not receive it, and you won't meet the deadline for that material to be entered into the record. And I do have one more slide, so just to reiterate the dates, this is for the 777, and I will update the county website with this information as well, in case anyone needs to reference this again.
Okay, thank you, Ms. House. So everyone has those instructions, and just check my notes, make sure I don't want to cover anything else. I think with that, we will close this hearing. The record will remain open. The written record is going to remain open until March 1st for any participant to submit evidence or argument, until March 8th for rebuttal purposes only, and until March 15th for the applicant to do a final legal argument. So with that, we can adjourn.